and he's serving as a settlement week coordinator for the Eastern District, Southern District of Ohio Federal Court since 2000.
I really did appreciate the invitation to come and talk to you all. And I know that I was asked to speak for about half an hour and then leave some time for questions. I could probably speak for half an hour. Anytime you get a lawyer and a bottle of water, you are in big trouble. But I'd prefer really to kind of give some general remarks, some of which I know are going to be very familiar to some of you here, and then hopefully be able to answer questions about either the court's mediation program or the court's philosophy about mediation or other things that may be of interest to you folks. I'll start, I guess, by talking a little bit about the Columbus Settlement Week program. And as I look around this room, I'm counting at least 1, 2, 3, 4, 5, 6 either current or former volunteer mediators in that program. So I know that this is going to be somewhat familiar, at least to those folks. A little bit of history, and some of you may recall this as well. Back, I believe, in the early 1980s, Harold Paddock, who was then a magistrate judge with the Franklin County Court of Common Pleas, started up a settlement week program in the county, the Common Pleas Court. And I actually remember participating in that as a practicing lawyer. And after that had kind of gotten off the ground and went for a couple of years, Magistrate Judge Nora King from our court looked at that model and thought that that would be something that we might want to try to import into the federal court. So roughly 1985, she started our current settlement week program in Columbus. And for those of you who aren't terribly familiar with the settlement week format, at least as we started it originally, the idea was that twice a year we would set aside a week during which cases would be mediated by attorney volunteers. And the thought was that you would bring in the parties and the volunteer mediator, match them up, give them space in the courthouse to do a mediation conference. Conference would last typically an hour and a half to 2 hours. And the hope was that we could dispose of a substantial number of cases by going through that process. It worked well enough over its first couple of years. And I think it was still twice a year when I started at the court, which was in September of 1987. That very shortly after that we decided rather than just do it twice a year, we'd do it 4 times a year. So for at least the last 20 years we've been running this program on a quarterly basis. And the basic format has really not changed. We have a group of volunteer attorney and I think at least one non-attorney mediators. Right now that group numbers about 150. And again, you folks who participate, you know this because you get an endless stream of letters from me about the program. We ask those folks ahead of time for their availability for each quarterly settlement week that we run. Once we get back those responses, we create a master list of who's available and what dates they're available. And then we match them up with cases that we've referred to settlement week. And so during the course of an average settlement week, and this has probably been true for at least the 13 years that I've been nominally in charge of the program in Columbus, we run somewhere around, I would say, 50 cases through the whole process. Typically we schedule about 100 cases each quarter for mediation, but we give the parties the ability to opt out if they don't feel like the case is really ready for mediation at that point. We probably lose about half the cases through an opt-out process. We send the rest through the mediation process, and an average settlement week in terms of results. We probably the rough average, last time I calculated, it was a couple of years ago, it was around 43% success rate, which we think is pretty good. A bad week is sort of in the low 30s. A good week is in the mid 60s. We've kind of done both of those, but we average in that 40 to 45% success rate. So that's the program. That's kind of the history of it. That's the way that it's structured. I guess the only other thing in terms of how do we actually select cases to be mediated, our typical process, and for those of you who litigate in federal court, you know this as well, there's actually a space on the initial report that you give to the court in advance of the first pretrial conference that asks you which settlement week you think the case ought to be referred to based on when you think it's going to be ready for mediation. and we give you that quarterly menu, and you just check one. And then I have a short discussion when I do an initial pretrial conference with counsel about that, and we agree on a particular settlement week, and then that just goes into our master list. So then when your case then comes up on the list, and right now we're doing September 2013, so we created our list from the series of initial pretrial orders where people have said that's their preferred settlement week, and we've sent out the initial set of orders already, getting people ready for that process. That's the way I do it. I know the other magistrate judges' approach to it is pretty similar. Maybe the only significant difference among the four of us now is that I have a very easy opt-out process. That is, I send out an initial order before the order actually setting the conference, which says, we've identified this as a case for this settlement week, but of course that could have been 6 months or 9 months or a year ago. If you're really not ready at this point, you just have to authorize one of the attorneys to call my courtroom deputy and say, we don't want to go this time, and then we just basically bump it down to the next settlement week. I think Judge King is the one that probably makes people jump through more hoops, and looking at the numbers, she actually typically has more cases that go to settlement week than anybody else, and because the success rate seems pretty consistent, I'm not sure whether my approach or hers is the better one. It looks to me like she's probably sending some people to mediation that I wouldn't, but it looks like about half those people are actually settling their cases. So the question, I guess, is which version is a little bit more lawyer-friendly, and I guess mine tends to be a little bit more that way. But that's the way we generally run the program. Now, there were efforts from time to time to create a similar program in Dayton and Cincinnati, which are the other two seats of court in the Southern District of Ohio. They're both in the Western Division of the court. And they really never got off the ground. Some of you may have had some experience with cases in Cincinnati or Dayton going through settlement week, but my sense of why it didn't kind of catch on in those two locations is that they didn't have the pre-existing experience of the common pleas court and sort of the buy-in of the bar and the litigants in their particular areas to make the program work, because that's the reason it works, is that first of all, we do have this incredibly talented pool of volunteer mediators who are willing to do this for us. We ran a CLE program for mediators about 6 or 8 years ago, and when we got our enrollees for that, I think we had 60 people who went through the training. I went back and looked at their average years of practice, and it was over 25 years of practice experience for the group that signed up for the mediation training, and they're all on our list of mediators. So that gives you a sense of the level of experience that we've got from folks who wanted to do it. So that's an important part of what makes it go. But the other part is that the lawyers who litigate in federal court also believe that it needs to be a meaningful process. So when they do come to mediations, my experience is they are typically, with some exceptions, prepared to do a meaningful mediation and committed to having it be an effective process. I think one of the reasons why Common Pleas Court sort of dropped the program after a while, and I think some of it had to do with the fact that Harold retired and he was running the program, but I had the sense that people didn't take it as seriously as they do in federal court, and so you got a lot of mediation conferences that really weren't very meaningful because people were there because they had to appear and not because they actually felt like the case was ready to mediate. And so it became a process that really wasn't producing good results for anybody involved. So I think we're just very fortunate that we piggybacked on that model, and then the folks who practice in our court have really made it work. So that's settlement week in a nutshell. I have some other things to talk about in terms of district-wide mediation practices, but before I move on to that, anybody have any questions or comments that you want to make about our settlement week process?
What do you do, Terry, when Magistrate Kemp, when you got one of the parties that wants to go through the mediation and one doesn't?
And that does happen occasionally. My procedure for that is to have them call me on a conference call, and I will talk to both parties about why it is that they either feel the case is or isn't ready. And if I have a sense that despite one side's protestations that they're really not ready to mediate, that in fact it would be useful, then I pretty much make them do it. On the other hand, if I get a real sense that it's going to be a complete waste of everybody's time, then I don't force them into the process, but I at least explore that question with both counsel if I get that kind of an advance.
And I noticed on the last sheet, you now have the option for 3 hours as opposed to an hour and a half, which Is that what you were going to say?
Yep. Thank you.
Which I really congratulate you on doing. An hour and a half on most of these, you just can't do.
Yeah, and certainly from my experience mediating as well, I understand that a lot of times you need more time. That actually was a suggestion that was pushed pretty hard at a meeting of the Columbus Bar Association. I think it was the Federal Courts Committee that I spoke at a couple of months ago. And that was, if there was one thing that came back to me from the group of folks I was talking to, there it is, we'd like to have more time. We were always concerned that because we're asking people to volunteer, we don't want to abuse that by forcing people into larger time frames. So what we've done now is we give you the option of again, volunteering for up to 1.5 to 2 hour time slots, or you can pick one longer time slot, either 3 hours in the morning or 4 hours in the afternoon. And we did change the form just for this one settlement week to accommodate that. That creates a little bit of an administrative issue for us because now we've got these sort of two separate tracks, and we're not really sure which cases need to go in the longer time slots, which ones need to go in the shorter time slots, how we're going to figure that all out. I think probably what we're going to do is just do sort of a random selection like we always do of cases and mediators, and so some people will get the longer time slot and some people won't, and we'll just kind of see how it works out. But we're new into that process. So we're going to be evaluating that to see how it goes. But I really appreciated the feedback from the bar on that. Yeah.
Two related questions. One, does your process allow for spillover time if it's warranted by the content of the mediation?
Yes and no. How's that for a definite answer? Ordinarily, we certainly don't restrict people to that time slot. What you run into sometimes is that the room that we've booked you in has been booked for the next time slot. So after an hour and a half or 2 hours, somebody's going to come by and say, we need this suite of rooms for the next conference. My experience with most of our mediators is they don't let a little thing like no rooms faze them. If they're into the middle of a process and they think it's going to be productive, they'll just ask if there's someplace else they can go. Or actually, this happened on 9/11. That was actually a settlement week conference day at our court. They closed the courthouse. We actually had some mediators take the participants outside on the lawn next to the courthouse and finish their mediation there. So people are very creative about that creating extra time. We're certainly happy to try to accommodate that, but sometimes just logistically we don't make it as easy for you as we should.
Follow-up question, if I could. In the event that a mediation lasts for the allotted time and it can't extend over because of scheduling difficulties, does the court make facilities available if the parties and the mediator want to come back on a day other than the settlement week?
Yeah, we will absolutely make room in the courthouse available at any time for that kind of a process, or alternatively, if the mediator would prefer to do that at his or her location, we do that too. So either one of those is available.
I was just going to comment, I have continued some in my office that, a week later, 2 weeks later, we make a lot of progress, but somebody has to go back and check or do something, and that's worked out.
Yeah, and hopefully, I look at all of the check sheets that you all fill out, and I look at the comment section, and if something like that is going on, I'll try to alert my courtroom deputy so she can contact you, find out when the follow-up is scheduled, get a notice on the docket so we've actually got kind of a paper trail that that's what's going on. But and again, we really appreciate the way you fill those sheets out and give us that information so that we can track that stuff.
Well, occasionally I do have to be reminded.
Yes.